Hello, and welcome to Healthcare Matters, where the medical and legal communities come together to discuss healthcare matters. I'm your host, Mike Matray, and today's guest is Troy Bundy. Mr. Bundy is a hiring partner at Hart Wagner in Portland, Oregon, where he has been defending healthcare professionals since he joined the firm in 1996. Welcome to the show, Troy.
Thanks, good to be here.
You were involved in a significant case in Oregon, which involved shoulder dystocia. Could you tell us about that case and what made it significant and how it played out?
Yeah, it was a case actually that I lost, the case played out typically as a shoulder dystocia case does, which is a patient went in and delivered a baby. The baby was large, and the allegation was that there was a shoulder dystocia encountered, which there was. Maneuvers were employed in order to relieve pressure from the shoulder and prevent the typical injury, which is a brachial nerve palsy or brachial plexus injury. The baby ended up with residual problems with his shoulder and arm. And I've tried a number of those cases. What was unique about this particular case was the fact that the mother had experienced a prior shoulder dystocia, and that she didn't know that she had a prior shoulder dystocia.
How did you discover that she had a prior shoulder dystocia?
Well, the whole crux of the case was the fact that the documentation of the shoulder dystocia was in the delivery report or the delivery record, and the delivery record was part of the clinic file. But the way the clinic worked was, people have more than one child over the years. And rather than carry forward the entire chart, which was essentially converted to an EMR, a new mini chart would be created for the patient for the new pregnancy so that there wouldn't be, a large chart to deal with all the time. So the information was there, and I saw it in the medical records, as did the plaintiff's attorney. But the doctor didn't review all of the medical records. And when the nurse asked the patient if she had any prior complications associated with previous pregnancies, the mother responded no. And so the case was managed as though there was no prior shoulder dystocia. What was interesting was that the physician who charted a shoulder dystocia charted a lot of shoulder dystocias. He encountered an extraordinary number of shoulder dystocias in the course of his practice. And so what we were dealing with was what the literature routinely refers to as an overcall. This is, whether or not a shoulder dystocia really occurs is ultimately something that the physician determines at the time of the birth. Obviously, there's going to be times when, that's a shoulder dystocia, but there are going to be more subtler forms that most obstetricians will not refer to as a shoulder dystocia. They just won't call it that. And that's really what this was a judgment call that one physician made. The downside of the case was that it was well documented in the chart. It ultimately proved to be too much to overcome. But the thing that I learned in that case was that this trial tactic, it seems obvious now that I've had it occur to me. But one of the things that the plaintiff's attorney did was he moved to admit the medical records that had been prepared and submitted to my expert for review. And those records were really no different than any of the other records that we had admitted in the case. We didn't object to the admission of our expert's file, essentially, or a portion of the file to be admitted into evidence. So that was in, and nothing really occurred with it, and the plaintiff's attorney didn't say anything about it until closing argument. And then all of a sudden, in closing argument, the plaintiff's attorney referred to an ICD-9 code that said shoulder dystocia and made an argument that the words shoulder dystocia were included in the file materials that we had, and our provider knew about it, and that we were somehow hiding the ball, and so on and so forth. But the lesson I learned was that whenever we agree to admit an exhibit, even if you don't talk about the exhibit during the course of the trial, it's open season and fair game for closing argument. And you can make whatever argument you want, however far-fetched an argument the plaintiff wants to make about whatever piece of evidence has been admitted is fair game. And that left us with trying to respond and explain to the jury, which was basically impossible because evidence had concluded that, hey, this is an ICD-9 code. That is something a coder came up with. That is not part or seen in the EMR when our physician was looking at the chart. I mean, so the lesson I learned was be very, very careful what you agree to as far as the admission of evidence. And just because something is not discussed during the course of trial and doesn't come up during the course of trial, that doesn't preclude the plaintiff, or if the defense wants to use it, the defense, from making an argument to the jury at the end of trial that the other side can't respond to or legitimately respond to. And so I learned my lesson during that trial about the power of an admission of evidence, and whether somebody can create an issue that never existed throughout the course of trial by raising it at the last minute during closing argument.
Without an opportunity to respond.
With no opportunity to respond, right.
Well, Troy, I'd like to thank you for coming on Healthcare Matters today. It was wonderful to have you as a guest, and I hope you'll come on again soon.
Thanks.
A relatively recent phenomenon in healthcare delivery has been the expanding availability of healthcare services in America's big box retail stores. CVS recently purchased Target's in-store health clinics, making it the largest retail healthcare clinic chain. How do liability risks differ in these big box retailers as opposed to a doctor's office? And how would you recommend these new healthcare delivery sites mitigate their risks?